Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Wheelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Law Days and Lattes. Good morning, and welcome back to Law Days and Lattes, where we talk about life, law, and everything in between, one sip at a time. I'm your host, Sidney Wheelan, owner of the Wheelan Law Firm, now with offices in both Moberly and Carrollton, Missouri. Today, we're tackling one of the most common questions I get as an estate planning attorney. What's the difference between a will and a trust? If you've ever Googled, do I need a will or a trust, and gotten overwhelmed, this episode is for you. We're going to simplify it. No legal jargon, just plain talk about how each one works, when you might need them, and how they protect the people and things you care about. So first, what is a will? Let's start with the basics. A will, also known as a last will and testament. It's a legal document that says who gets your stuff when you die. With a will, you can name who inherits your assets, appoint a guardian for your minor children, choose someone to handle your affairs, called a personal representative or an executor. But here's the catch. A will does not avoid probate. A lot of my clients are surprised by that. Probate is the court-supervised process of distributing your assets. It's public, sometimes expensive, and can take months or longer to get through the process. Next, what is a trust? Let's talk about trust. A trust is a legal entity you create to hold and manage your assets during your lifetime and after your death. One of the most common types of a trust is a revocable living trust. With a trust, you can transfer assets directly to your beneficiaries without probate, provide for loved ones over a longer period of time if you choose, set conditions for how and when assets are distributed, maintain privacy, because trusts are not public like wills. Trusts don't have to be recorded or filed anywhere. And it's really nobody's business what's in your trust or how it's distributed unless you tell them. And you can plan for incapacity. You can name a successor trustee to manage things if you're unable to, for any reason. Trusts can even offer protection from lawsuits or remarriage risks, depending on how they're structured. So the key differences between the two. Let's break it down with a side-by-side comparison. So, which one goes into effect? After death, that would be the will. The trust is effective as soon as it's signed and funded. The will requires probate. The trust, if it's properly funded, does not require probate. The trust will control assets during your lifetime. Remember, the will is only effective at your death. Only with a will can you name a guardian for your children. You can't do that in a trust, but you can use the will alongside a trust if you have children. Usually, the will be less expensive than the trust. The trust requires more upfront, but it will probably save you on court costs and attorney's fees later. So, our next segment, which one do you need? Well, here's the honest answer. It depends on your goals, your assets, and your family dynamics. You might want a will if you have a very simple estate, if you're okay with the probate process, or if you need to name a guardian for minor children. However, you might want a trust if you want to avoid probate like most of my clients, or you have property in more than one state. A trust is also good if you want to protect a loved one's inheritance. For instance, holding sums or accounts in an account for grandchildren's education or for a special needs beneficiary if they're not able to handle the funds immediately. And for many people, the best answer is that you actually might need both. A trust to handle the money and the property, and a will that names guardians, and perhaps a pour-over will that catches anything that you've inadvertently left out of the trust. So, for your final sip of coffee, peace of mind comes from planning. At the end of the day, a will or a trust isn't just a legal document. It's a gift. It's a perfect way to protect your loved ones, prevent confusion, and make sure that your legacy is handled the way you want. So, if you've been putting off your estate plan because you weren't sure what to choose, you're not alone. But you can take the next step. And if you need help figuring it out, well, that's what we're here for. Because peace of mind doesn't come from guessing. It comes from planning. So, thanks for joining me on this episode of Laudes and Lattes. If you've learned something new today, share this episode with a friend or a family member. It could help them protect what matters most. And if you're ready to get started on your own estate plan, let's talk. Visit us at wheelanlaw.com to schedule a consultation. So until next time, my friends, stay grounded, stay informed, and stay prepared. Have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.